Very much, Judge Alim Fisram. Before we conclude our judgment, we are constrained to comment about the conduct of counsel for the third petitioner, Mr. Ochiel Dudley. On 19th of June 2023, he authored a letter addressed to the Deputy Registrar titled Professional Duty to Disclose, requesting the Deputy Registrar to bring to our attention a recent decision of the Supreme Court whose findings would aid us to deal with the present consolidated petition. At the time of the letter, the proceedings had been closed and a date for judgment set. We thus found the conduct of Mr. Ochiel inappropriate. For obvious reasons, we did not refer to the decision he referred to, and it was not necessary to do so. These are our final orders. Having answered all the issues that we framed in the consolidated petition, we now make the following final orders. A, that the current Office of Chief Administrative Secretary, created by the first and fifth respondents and contained in the Kenya Gazette Special Issue number 12432, dated 12th of October 2022, and which announced the vacancies thereof, is unconstitutional. B, that whereas there was some reasonable public participation on the first complement of 23 Chief Administrative Secretaries, there was no such participation regarding the additional complement of 27 office holders. C, that the entire complement of 50 Chief Administrative Secretaries, which is to say all the second to the 51st interested parties, is unconstitutional. D, for the avoidance of doubt, the notification by the first respondent dated the 16th of March 2023, appointing the second to 51st interested parties to the office of Chief Administrative Secretary is hereby quashed. E, that the prayer that Section 26, subsection 2 of the Salaries and Remuneration Commission Act and the Salaries and Remuneration Commission, Remuneration and Benefits of State and Public Officers, Regulations 2013, be declared unconstitutional is disallowed. F, a declaration is hereby issued that the first respondent enjoys constitutional immunity from suit and was illegally joined into the proceedings. G, that the petition against the first interested party, controller of budget, is hereby dismissed. The last issue relates to costs. Costs ordinarily follow the event and are at the discretion of the court. We find that the consolidated petition raised constitutional issues in the public interest. The order that commends itself to us is that each party shall bear its own costs. Thank you. Thank you, Dr. Kamodo. If you can give us just 1 minute to sign our judgment.
Shall I ask Mr. David, the President, to please make this
All right. Now, Dr. Kamodo.
Yes, my Lord, we are enormously grateful for the well-written decisions that the court has rendered.
Yes.
And we will be requesting for copies of the judgment at the earliest stage, as well as the proceedings. Further to that, we will be making an application for the stay of the decision of the majority to enable us seek a second view at the appellate court. We'll be seeking for a stay of 60 days, which we believe is sufficient to enable us to process the proceedings and to prepare a proper record of appeal for delivery at the Court of Appeal. And this is founded on the reasons that we believe we have reasonable grounds of appeal. First, we will be raising a question of jurisdiction at the appellate court. And just like the Honorable Court was able to arrive at different findings, we will also be seeking answers partially to some of the issues that have been decided, including the question of public participation, which in our view will be arguing that was adequate. We believe it is necessary that a stay be granted because as we start now, we believe the court has properly laid it out that it cannot interfere in any way with the decision of the employment court in ERC number E174 of 2022, and therefore, as we speak, the first respondent is at liberty to appoint 23 CSs, but will be pleading the case for the extra 27 when we get to the Court of Appeal, because we believe that the respondents, the interested parties, would be constitutionally entitled to the right of appeal, which would be fundamentally obliterated if a stay is not granted. It will also be necessary that the various competing decisions of courts of coordinated jurisdiction including the majority and minority decisions, are harmonized, and our only port of call is at the Court of Appeal. And given that we are persuaded that we have an appeal that is promising and stands high chances of success, we will be praying that the court be pleased to stay the orders issued today to enable the interested parties get the final position as would emerge from the Court of Appeal. I'm grateful, my Lord.
Thank you, Dr. Kamodo. All right. Is there any other counsel joining in the application by Dr. Kamodo? Let us know.
The issues raised by Dr. Kamodo. My Lord and my Lady, you will note that the issues raised in this matter are fairly heavy. not just heavy for the interested parties and the respondents, but for all the Kenyan people who also desire and who benefit from the services that have been rendered and are supposed to be rendered by the CAS. My lords, my lady will also note that the issues were heavy to the point that even your lordships have been unable to take a common position on all of them. It is therefore, in my humble submission, fair that we interrogate these issues further, as we are lawfully entitled to, before a final position can be taken on the matter. My lords and my lady, you will note further that there is another decision by a court of concurrent jurisdiction that is being affected by this decision, given that the position taken by the majority decision is not on board with the position that has been taken by the Employment and the Legislation Court. It will therefore be proper that any adverse implications of this decision be stayed temporarily so that finality can be achieved on some of the issues. Lords and ladies. In that, we believe will not be too much, and besides, it will be in the best interest of justice.
Thank you, Dr. Arwa. Mr. Wanyama?
Yes, my lord. I also agree that the peculiar circumstance of this matter, from a public policy standpoint, especially on the fact that there's a decision from the Employment and Labor Relations Court. We have the Murima decision. And then now you have this bench majority decision. Ordinarily, members of the public would want consistency on what is coming from the courts. And the best way to resolve that question of apparent conflict of decision from the courts is through the appellate mechanism. And public policy will then support that approach. My proposal will be that given that the status, a stay of 90 days as opposed to 60 days. The 90 days will be sufficient enough to warrant an interrogation even at the preliminary stage of the Court of Appeal on that question for institutional stability. On the question of prejudice, the petitioners don't suffer prejudice if stay is granted for that fundamental question to be interrogated. The reason is that this is a matter which is a decision in grant. Therefore, they have no nexus, as it were. It benefits the public if the Court of Appeal determines that question. So we'll be asking for 90 days. Thank you.
Thank you, Mr. Wanyama.
Yes, my lord.
Yes, Mr. Bicha?
I wish to join the application seeking a stay of the decision of the Honorable Court. My lord, the first point I will make is that the court has jurisdiction to issue the order sought, which is within your purview. The second point, my lord, is that from the perspective of rights of the interested parties, my lord and my lady, this dispute touches on fixed term contracts, and which, if the decision of the Honorable Court is to take effect, is not reversible